thank you very much. I'm glad to be here. The funny thing is, 10 years ago in 2009, I spoke on this stage at this conference giving this presentation. It was in Kansas City that year, but it's not only the markets that are cyclical. This is something that I dealt with quite a bit for a couple of years. People had the very same questions that are coming up today. And while it was a different program, a different flavor, a different look, there's the same legal issues involved. So with that, I do want to recognize that it was not just me that wrote this white paper, although it was based a lot on my research from a decade ago. But Tiffany Dowell-Lashmet, who is with Texas A&M University, and she is an attorney that does a lot of work very similar to the stuff that I do down there in Texas, and the two of us worked together to put it together. It is in the folder that you picked up at the beginning of the conference for those of you who still have it. I believe you all have it on your website, but at the end of my speech, I also have a link to it. So if you're interested, let's talk about it. So the paper covers two different topics. It covers confidentiality of information, and it also covers liability. So for the purposes of what I'm talking about today, and in order to conform to the time limits, I'm just going to cover the liability portion. If you are interested in reading more about confidentiality, I'd refer you to the paper, but I'm also going to say that it's going to depend a lot on what this process and what this program ultimately looks like, whether it's in the hands of the federal government, state governments, or private parties or private industry. The confidentiality in terms of the information that's available and who can obtain it is going to look very different. So with that, let me turn your attention then to, does traceability mean liability? This is the only time you're going to hear a lawyer say a one-word answer, which is no. Unfortunately, they gave me the stage for 20 minutes, so I figure I probably should fill it up with the rest of that lawyer speak. Traceability of animals in and of itself is not and does not lead to heightened levels of liability for producers. However, there's that lawyer speak for you. What it does do is it allows more traceability to people within the supply chain who had previously not been able to be identified. So you have always been responsible for the actions that you take and the animals that leave your farm. But before any kind of a system of traceability is put into place, once you get a couple sales down the road, it's very difficult, if not impossible, to trace it back to you. As a result, because it can't be traced back to you, it's very hard to bring you in as a defendant in a courtroom. Once you have a system in place of traceability, it's a lot easier to identify all of those little stops along the line. But it is really important to note, you have always been responsible for the actions that you take. You have always been responsible for the animals that leave your farm. That's not going to change no matter what kind of system is put into place. So it helps to identify the animals along the chain of custody. It helps identify the people who have been responsible for those animals along that chain of custody. And it may also, in addition to identifying all of those people along the supply chain, it may broaden the scope of people who can be responsible without identifying who actually is responsible. All that means is more people are brought into lawsuits, even if they cannot necessarily be shown to be responsible for that action. So if you are brought into a lawsuit, in terms of liability, there's three different ways that liability would be attached to you. So what this means is, these are just sort of theories of the case. If you were the defendant in a lawsuit, if someone brought a lawsuit against you, they were the plaintiff, you're the defendant, what they would do is they would argue all three of these. So you're not going to say, I'm liable under negligence, or I'm liable for strict liability. It's not going to be like that. The complaint's going to list three different causes of action, and they're going to try to throw everything at the wall, and hopefully something is going to stick. These are the things that they're going to throw at the wall. The first of them that I'm going to talk about is warranty, or a warranty theory. When we're talking about warranties, there's two different flavors. You have express warranties and you have implied warranties. Express warranties are something that you promise. So if you say, this cow can do X, Y, and Z, or this cow does not have this disease, that is an express warranty. You are expressly saying, this is a feature or not a feature of this animal specifically. All right? Implied warranties, on the other hand, they are warranties that are put into place to protect buyers, so that buyers have some idea that the thing that they are buying is good for the purpose that they are buying them for. The Uniform Commercial Code is what sets out this idea of implied warranties. The Uniform Commercial Code is put together by a bunch of law professors and attorneys and judges that have assembled this idea of what, in a perfect world, state legislatures would adopt in order to protect consumers and make sure that business runs smoothly. It's not a perfect world. So all 50 states have adopted parts of the Uniform Commercial Code, haven't adopted others, have changed some that they have adopted. So this is different in all of the states. But when you look at the Uniform Commercial Code and the way that it was passed in the majority of the states, they have this idea of an implied warranty. There's two implied warranties that I'm going to talk about today. One of them is the warranty of merchantability, and one of them is the warranty of fitness for a particular purpose. Now keep those in mind. They're sort of in their placement. You have express, you have implied. We'll get back to it in a couple slides. The thing with implied warranties is that only merchants can give them. And this is going to be important. This is one of those lawyer things that you have to really get down into the weeds. So I apologize for having this big, long definition of what is a merchant. But it is important. You can see this is the definition under the UCC of what is a merchant. Now you're wondering, why does this matter? All right? The question is, who is going to be a merchant? And as a result, who is going to be held to these implied warranties under the UCC? Who is a merchant? If you are a feeder, a packer, a distributor, you are more than likely going to be a merchant. Remember? Go back and look at that definition. It comes back to the professionalization, individual knowledge, that kind of thing. All of those are going to add up to becoming a merchant. If you are in that area of the supply chain, you're probably going to be held to be a merchant, and the products that you distribute would have that potential implied warranty attached. If you are a producer, so cow-calf operation, that kind of thing, courts are actually split as to whether farmers are considered merchants. Again, this is important when you're talking about implied warranties. So, whenever you say courts are split, what that means is they've put together this list of things that is important to be considered a merchant. And then they take each case and they apply that case to this list of elements. And in this case, the factors or the elements that courts will look at into determining whether a farmer is considered a merchant is what we have on the board. The length of time they've been there, the degree of business skill, their past experience. In other words, their level of professionalization would be considered in determining whether or not a court will consider them to be a merchant. Courts, as I said, are split, which means courts have found both ways. So this is one of those situations, again, with law, there's very few yes and no answers. This is one of those situations where a farmer, so cow-calf is what I'm sort of considering the farmer, would be whether or not it would be considered a merchant, and as a result have these applied warranties attached. Long story short, can a warranty theory lead to liability? If you are sued and somebody says, this is the foundation of my case, can it lead to liability? If you make express warranties, if you say, This cow does not have, has no sickness, is completely sound, whatever that warranty is, you can be held to that. The statements that you make, whether verbal or in contracts with buyers, can and will be held against you. So a warranty theory, that idea, express warranty, can attach and probably will attach. And this is really important if you don't just sell at the sale barn. If you contract with people down the supply chain, this is where this is going to come into play. So if you make express warranties, the answer is yes. Liability can attach. If you do not make express promises and you are considered a merchant, so getting a couple steps down that line. So no express promises and a merchant, that's when this idea of implied warranties are going to come into place. Maybe. The two warranties, as I said, are the warranty of merchantability and the warranty that it's fit for a specific purpose. When you're talking about a warranty of merchantability, say you want to buy a chute to work your cattle, and you go to a place that has chutes, talk to a salesman and say, this is what I want to do. I want to be able to work 100 cattle in a day, and this is what I need to do. They walk you to the chute and they say, this is the setup that you need. All right? So this was where the warranty of merchantability would come into place. You would be able to work. It's fit for the ordinary purpose for which it's used. All right? Setup, chute, setup, ordinary purpose is working cattle. If you had a problem working cattle in it, that warranty of merchantability would be one of the issues that you'd be able to litigate if you brought a lawsuit. When you're talking about a warranty of fitness, you go to that same place, you're looking to buy a chute, and you say, I'd like to be able to work my cattle, but in addition, I have a very small herd of buffalo, and I'd like to be able to work them as well. That same salesman takes you over to a chute and says, this is the one you want. All right? This is where the warranty of fitness for a particular purpose comes in. You are relying on that salesperson's superior knowledge of the equipment, one. And two, the salesperson knows the purpose to which you are putting it. So if you run your cows through it, it's just fine. You try to run your buffalo through it, and it goes straight through. After the salesperson said, this is the one you need, now you're looking at an idea of this warranty of fitness for a particular purpose. Again, this is this implied warranty. So if you have both of those things, those are both possibilities, assuming you're considered to be a merchant, that you could be looking at liability under. But there's another quirk. This is why they have lawyers, I guess. Because in many states, about half of them, just under half, the state governments have passed state laws, so it applies within that state, that prevent liability from attaching to livestock producers, prevent liability under implied warranties from attaching to livestock producers. So this is not express warranties. You can still be held to any promises that you make directly. But in these states, if a plaintiff is attempting to hold you responsible under an implied warranty theory, then they won't be able to do so, as long as you fit the parameters. Passed in about half the states, as I said, and there's several general ways that these laws are written. You're going to have to look at your specific state to see what applies to you. But in some states, there are statutes that are limiting or excluding livestock in general from any warranties. In some states, it limits the livestock warranty to disease. In others, it limits it only to if you know or don't know that there is disease in that herd or flock to start with. And finally, there's one state that limits the exception only to producers that affirmatively report that the animals are free of disease. So again, this is something that's going to be very state-specific. But if you are in a state where this applies, it can be an exception to being held responsible under this idea of an implied warranty. So that's one of the three ways that you can be held responsible. Another one is under this idea of a products liability theory. So products liability is imposed not only on things like meat products or livestock, it's imposed on any kind of a product. And when you're talking about products liability, it is imposed when a defective product is introduced into the stream of commerce. The plaintiff, or the person that's bringing the case, has to show that the product caused the harm. And that's what they have to show. The defendant is held to what's called a strict liability standard. And what does that mean? What is your defense if it is a strict liability standard? Is it a defense to be careful? Is it a defense to exercise due care? Or is it a defense to act reasonably? No. With strict liability standards, when you have cases such as products liability that are held to this standard, the question is, did the product cause the harm? If the answer is yes, then you can be held responsible. There's no defense, there's no justification, it's just, did the product cause the harm? Under strict liability, you can be held liable, you can be held responsible, even if you're acting in completely good faith. You had nothing, no bad actions at all. When you're looking at strict liability, you sort of have two parts to it. You have the defective condition of the product, and you have a causal connection between the product and the injuries. Usually, the second factor involves some level of proof that the product didn't change from the time it left the producer's hands to the time that it got into the person that was injured's possession. And that is where sort of the issue is going to arise and the possible protections are going to arise for producers. Can products liability lead to liability? And this answers to this is going to depend very much on where you're at in the supply chain. If you're on the packer or the retailer level, anything after the slaughter, the answer is going to be an unequivocal yes. Products liability can indeed lead to liability. If you are before that, however, for that to happen, animals would have to be considered to be products. Because remember, it has to be a defective product introduced into the stream of commerce. So animals, living, breathing, moving animals, would have to be considered a product. And states have been very leery about whether animals themselves can and should be products. In fact, the majority of courts say that they're not because they are changing beings. They're mutable, changing nature. It changes substantially from a cow that you're feeding out on your place to the time it gets to a steak in the market, right? Because of that change, courts have been very leery about imposing strict liability standards on people that own and sell animals. There are, however, a few states that have. So far, it has been limited to the sale of pets that have been considered products. But if you are in New York, Oregon, or Connecticut, you have had courts that have said that an animal, a living, breathing animal, is indeed a product. In addition to that, the restatement of torts. I said the UCC was a bunch of law professors and judges and attorneys that got together and they wrote this document, how things should be. The restatement of torts is the same way. There's restatements in lots of different areas of law, and this is one of them. All right? The restatement of torts is a bunch of tort professors and people who practice and judges that say this is, in a perfect world, how the law would act, would be. The third restatement of torts, which is the most recent version, argues that animals should be considered products. So this is not something that has been adopted by any states so far, but it is something that's out there. So right now, unless you're in one of these three states, you're probably pretty safe, as long as you are on the beginning part of the supply chain in terms of products liability. But especially with the restatement out there and some case law in different states showing otherwise, it's not something for sure, absolutely. Probably, so we've covered 2 out of the 3, and the third one is probably where the most liability is going to attach. This is probably the one that you're going to have to rely on if you are a plaintiff bringing a lawsuit. And that would be the idea of negligence. Negligence is the failure to exercise reasonable care. I wish there was a definition that I could give you, but there really isn't in this case. The definition is what a reasonably prudent person would do in the same or similar circumstances. Beyond that, it's going to be up to the trier of fact to figure out who is a reasonable and prudent person, what would they do, and what are the circumstances that they would do it under. All right, so that can vary very much, but long story short, what it probably would end up with is, what would another cow-calf producer of about the same size, operation, same level of experience, same level of knowledge, what would this person do in that situation? And this is what the plaintiff will have to prove in order to hold you responsible. First, they would have to prove that you had a duty. Were you responsible for doing something or responsible for not doing something to a certain person, to a certain animal? So did you have a responsibility to do X, Y, and Z and you didn't do it? Or did you have a prohibition on doing something and you did it anyway? So are you feeding it something that you're not supposed to be feeding it, for example, and then sending it on down the supply chain? Is there a breach of that duty? Did you fail in your responsibility? Did you do something you were not supposed to or not do something that you are obligated to? Harm. Did somebody get hurt? Without harm, you're not going to have a lawsuit. And then finally, causation. And because when we are talking about traceability and liability, a lot of times there's a huge difference between the cow-calf, in time-wise, between the cow-calf producer and the time the consumer is injured. And the causation is where that link is going to come into place. Can you prove that the actions that this cow-calf producer did made it all the way down the line, and that's the reason you got hurt or you got sick? So were you the reason that somebody got hurt? And could you have foreseen that somebody would get hurt? If you are giving the animal something, drugs or feed or something that you're not supposed to, that you're prohibited from doing, trace it down the line. So, one, were you the reason that somebody got hurt? Can they prove that your actions led to that injury? And two, can you foresee that that would happen? Can you foresee that your bad actions would turn into somebody being injured? And if they can prove all of those things by a preponderance of the evidence, then you can be held responsible. So a negligence theory can lead to liability if a plaintiff, a producer, feeder, processor failed to use reasonable care and that failure led to an injury down the road. Then a producer, processor, feeder, whatever, can be held responsible. Unlike strict liability, there are ways that you can reduce your risk with negligence claims. So obviously the first one would be using best management practices, not doing anything you're not supposed to do, not violating that duty that you have to act in a certain way. But in addition to conforming to best management practices, another way to reduce your risk is documenting that you conform to best management practices. So paperwork isn't fun for anybody, but when you are looking at negligence claims, paperwork is something that can save you down the road. So things like treatment records, animal health programs, inputs, quality assurance records, all of those things can help protect against a negligence claim being successfully brought against you and your operation. So let's put this all together. We have a plaintiff who's a consumer, contracts, for example, E. coli. The plaintiff will file suit against both the retailer and the packer for negligent handling of the meat. All right? They can identify where they purchased it. They can identify who the packer was because it's going to be the labeling on the piece of meat. If the packer has a traceability system within their plant, then the packer can trace it to the feedlot owner. So the feedlot owner can be brought in as an additional defendant. If there is a comprehensive traceability system in place, or it can go back even further than the feedlot, then others can be brought in. And I'm not saying by any means that successful claims can and will be brought in the majority of cases, just because there's a huge length of time between when you have a cow-calf operator and by the time a consumer will ultimately consume that meat. But it's not always about the ruling. It's about the time you spend in the courtroom. It's about hiring an attorney to represent you. It's about all of those additional fees and additional costs that it could take in the meantime. So what they would argue, to hold them responsible, the plaintiff would have to show the responsibility based on the three things that I talked about today: warranty claims, product liability, or negligence. If they could hold them responsible, then there's a potential ultimately ruling in favor of the plaintiff against the defendants. If they can't, the defendant, which is anybody along that supply chain, is still going to be responsible for the time they spend in the courtroom, still going to be responsible for the time that they have to spend defending, time and energy that they and their attorney have to spend defending the claim. So back to what I said at the beginning. There is no ultimate change in the liability. You are still going to be responsible under any of these theories for the actions that you take and the animals that you raise and sell. The only difference is the level of anonymity is much lower. So it's a lot easier to identify all of those stops along that chain. So I'm very happy to send this presentation to anybody who wants to spend a little bit more time looking it over. My contact information is on this slide. You have a copy of the paper that Tiffany and I wrote in your folder, but if you don't have it or don't find it anymore, there is a link here that you can click on or that you can go to and download it again. With that, I'm happy to answer any questions.
Time for one question.
One question.
Thank you for that. It's very, very eye-opening. And this has been one of the reasons why lots of people don't want traceability. But my point is this. This is a very good reason why you should have traceability, because you can prove you were not in that chain. And what do you have to say about that?
All right. That is a great idea. And it's going to depend. Favorite lawyer answer, all right? Because there is this, in some states, in some cases, there's this idea of joint and several liability, which means that in some states, in some cases, the jury can say the defendants are responsible, and then so the defendants are responsible for, $100,000, right? Because of this joint and several liability, every single defendant would be responsible for that $100,000. And then the defendants have to go back among themselves and sort of fight it out and figure out who's paying what part of it and what level of responsibility lies with each one. So, yes, if you are completely found not responsible, then that's fantastic. However, if you are found to have some level of responsibility, if you get into this idea of joint and several liability, you can still be forced to sort of go to that second level and determine what level of responsibility and what level of payment each producer has, or each member of that chain has.